Priya sat in the waiting area of her doctor's office in New Jersey, 8 months pregnant, waiting for a Supreme Court decision that could determine whether her daughter would be born an American citizen or not. For 18 months, millions of H-1B, F-1, and green card families lived with that exact same fear. On June 30th, 2026, the Supreme Court finally answered the question, and the ruling reaches far further than most people realize. In this video, I'm breaking down exactly what the court decided, why this decision is now permanently final with zero further appeal, the 5 dangerous myths still spreading online, and precisely what expecting parents need to do next. Her husband Arjun sat beside her, scrolling through his phone and reading the same news story for the 3rd time that morning. He was on an H-1B visa. She was on an H-4 dependent visa. Their daughter was due in 3 weeks. For 18 months, they had heard the same warning repeated in immigrant community group chats, in family WhatsApp threads, and in late-night conversations with other H-1B families. A rule signed in January of 2025 had threatened to change something they had always assumed was settled. Would their daughter, born on U.S. soil, be recognized as an American citizen the moment she took her first breath? Arjun had read that federal courts kept blocking the rule. He had also read that the case was headed to the highest court in the country. Priya had stopped reading the news 2 weeks earlier because it made her too anxious. She just wanted to know one thing. When her daughter was born, would she need a passport application, an immigration attorney, and years of uncertainty? Or would she simply be American, the way every child born in a hospital down the street had always been? A nurse called another patient's name from across the room. Priya barely noticed. Her mind kept replaying a conversation from the week before, when her sister back home had asked, half joking and half serious, whether the baby would even have a country to call her own. Priya had laughed it off at the time. Sitting in that waiting room now, 3 weeks from her due date, it no longer felt like something to laugh about. Arjun looked up from his phone. "There's a decision," he said. Priya turned to him. "What does it say?" Millions of families just like Priya and Arjun spent 18 months living with that same uncertainty. On June 30th, 2026, the Supreme Court finally gave an answer. What the court decided changes what every expecting immigrant family in America needs to understand right now. And it may surprise you how far this ruling reaches. This story matters because it does not only affect one family. It affects every H-1B household, every F-1 student couple, every green card applicant, and every family expecting a child on American soil without permanent status. In this video, you will learn exactly what the Supreme Court decided, why the ruling is now final with no further appeal available, which myths about this decision are dangerously wrong, and what steps, if any, expecting parents actually need to take. By the end, you will know precisely where you and your family stand, and you will be able to explain it clearly to relatives who may still be confused or worried after months of conflicting headlines. Before we go any farther, here is how we build every video on this channel. We rely only on verified sources. That means official Supreme Court opinions, Department of Homeland Security statements, USCIS guidance, and reporting confirmed by established legal outlets. We separate confirmed facts from legal interpretation, and we flag anything that is still uncertain. Nothing in this video is speculation dressed up as fact. Let's clear up the confusion because there is a lot of it circulating right now. Myth number 1. Only children of U.S. citizens or green card holders receive citizenship at birth. Reality. The 14th Amendment has never worked that way. Virtually anyone born on U.S. soil is a citizen at birth, regardless of the parent's visa status, unless a very narrow diplomatic exception applies. Myth number 2. President Trump can still overturn this ruling. Reality. Supreme Court decisions are final. There is no higher court, no further appeal, and no executive order that can reverse a constitutional ruling of this kind. Myth number 3. This decision only protects the specific families who filed the lawsuit. Reality. The ruling applies nationwide to every birth in every state, not just to the plaintiffs in the case. Myth number 4. H-1B, F-1, and other visa-holding families are excluded from this protection. Reality. They are explicitly covered. The court's reasoning applies to children of parents on temporary visas exactly as it applies to children of undocumented parents. Myth number 5. This ruling creates something new. Reality. It restores the understanding that has existed since a Supreme Court case from 1898. Nothing new was created. An attempt to take away an existing right was blocked. Here is how we got here. The long-standing rule comes directly from the 14th Amendment to the Constitution. It says that anyone born in the United States and subject to its jurisdiction is a citizen. Courts have interpreted that language broadly for generations, and that interpretation was confirmed in a landmark 1898 decision involving a man named Wong Kim Ark. Under that rule, the standard practice was simple and consistent. If a baby was born on American soil, that baby was an American citizen. Full stop. No exceptions based on the parent's immigration status. The current legal fight began on January 20th, 2025, the day President Trump signed an executive order attempting to deny automatic citizenship to babies born to parents who were undocumented or present only on temporary visas. Federal judges across the country blocked the order almost immediately, calling it unconstitutional. Civil rights groups, including the ACLU, along with several state attorneys general, filed lawsuits within days. For a period, the legal battle was not only about citizenship itself, but about whether a single federal judge could block a presidential policy nationwide, or only for the specific plaintiffs before that court. That procedural question reached the Supreme Court first in 2025 and created confusion for families who assumed it had already settled the citizenship issue. It had not. The administration then pushed the actual constitutional question all the way to the Supreme Court, where the case was argued in April of 2026. The new update arrived on June 30th, 2026, when the Supreme Court ruled 6-3 in a case called Trump versus Barbara, striking down the executive order completely and confirming that birthright citizenship remains exactly as it was. In a 6-3 decision, the Supreme Court held that Trump's executive order restricting birthright citizenship cannot be reconciled with the 14th Amendment. Chief Justice John Roberts wrote the majority opinion. In plain English, this means children born in the United States to parents who are here without permanent status or on temporary visas are, in the court's own words, citizens at birth under the Constitution. The official source here is the Supreme Court's opinion itself, issued June 30th, 2026, and confirmed by multiple legal outlets, including SCOTUS blog. Think back to Priya and Arjun from our opening story. Under this ruling, the moment their daughter is born in that New Jersey hospital, she is an American citizen. No separate application, no special filing connected to this ruling, and no waiting period. Why this matters is straightforward. Families no longer need to plan around fear that a state-by-state patchwork of citizenship rules might apply to their newborn. The court focused on 4 words in the 14th Amendment: subject to the jurisdiction thereof. The administration argued that this phrase excluded children of undocumented parents or parents holding temporary visas. The majority disagreed, holding that nearly everyone physically present in the United States, regardless of status, is subject to its laws and therefore its jurisdiction. The real-life impact is that this interpretation directly protects H-1B, F-1, L-1, and every other visa category, not just undocumented families, which many headlines failed to make clear. The short summary is this: if your child is born on U.S. soil, the parent's visa type does not change the result. Because this is a Supreme Court constitutional ruling, there is no appeal process above it. It cannot be undone by a future executive order. In theory, it could only be changed by a future Supreme Court reversing itself, which is exceedingly rare, or by a constitutional amendment, which requires approval from 2/3 of Congress and 3/4 of the states. Chapter 4. What this means for passports and Social Security numbers. Because the executive order never actually took effect, hospitals, state vital records offices, and the Social Security Administration continued issuing standard birth certificates and Social Security numbers to every baby born in the United States throughout the entire 18-month legal fight. The official confirmation comes directly from advocacy groups involved in the case, including the American Civil Liberties Union, which stated plainly that the executive order never went into effect anywhere for any baby at any point. The real-life example here matters directly for our audience. If your child was born in the United States any time after January 2025, including during the months this case was still pending, your child's citizenship was never actually interrupted, and no retroactive fix is required. The summary is simple. Nothing changed in practice for any baby born during this period, and the Supreme Court ruling confirms permanently that nothing needs to change going forward either. But here is where many people get caught off guard. While births are now fully protected, a completely different citizenship battle is escalating for people who are already naturalized citizens. We will cover that story in an upcoming video because it affects a different but equally large part of our audience. Before I walk you through exactly what expecting parents should actually do right now, if you're finding this useful, go ahead and subscribe so you catch these breakdowns as soon as they drop. So, what should you actually do if you are expecting a child right now? First, no new paperwork is required because of this ruling. Hospitals continue issuing birth certificates exactly as before. Second, keep your own immigration documents current and organized, since this ruling does not change your personal visa or green card timeline. Third, if your child was born between January 2025 and June 2026, during the period the executive order was blocked by lower courts, your child's citizenship was never actually at risk. But you can still request a passport or social security number through the normal process if you have not already. Fourth, ignore any social media post claiming you need to file a special form referencing this court case. No such form exists. Fifth, if you have specific questions about your family situation, consult a licensed immigration attorney rather than relying on comment sections or forwarded messages. Sixth, if a hospital or government office ever asks you for documentation that seems unusual or unrelated to standard birth registration, ask for the specific legal requirement in writing before providing anything, and contact an attorney if something feels off. Seventh, keep a simple folder, physical or digital, with your child's birth certificate, social security card, and any passport application materials together, since these documents will be needed repeatedly throughout life for school enrollment, travel, and future benefits. Let's cover 5 mistakes we are already seeing people make. Mistake 1. Panicking and delaying prenatal care planning because of rumors. Some families genuinely postponed hospital selection or delayed registering for prenatal classes because they were unsure whether their child's status was secure. This ruling removes the uncertainty completely. There is no reason to delay medical planning, and no hospital in the country requires proof of parental immigration status to provide a birth certificate. Mistake 2. Believing viral social media posts claiming the ruling only applies in certain states or only to families who were part of the original lawsuit. This confusion spreads quickly because the earlier procedural fight actually was about state-by-state application. The final ruling is different. It applies nationwide, without exception, to every birth going forward. Mistake 3. Assuming this ruling changes the parent's own visa or green card status. It does not, and it was never designed to. Parents on H-1B, F-1, or any other status continue following their own separate immigration timeline exactly as before. This ruling addresses only the child's citizenship. Mistake 4. Confusing this decision with an earlier separate Supreme Court ruling from 2025 about nationwide injunctions. That earlier case was procedural and addressed which courts can block a policy nationwide versus only for specific plaintiffs. Many viewers understandably assumed that case had already resolved the citizenship question. This new decision is the actual final word on the constitutional question itself. Mistake 5. Assuming no further action is needed if a child was denied a social security number or passport application during the period the executive order was being fought, in a small number of isolated cases. If that happened to your family, do not assume the issue resolved itself automatically. Follow up directly with the relevant agency, now that the ruling is final, and request the standard documentation your child is entitled to. Let's bring this all together. On June 30th, 2026, the Supreme Court ruled 6-3 that birthright citizenship under the 14th Amendment remains fully protected, striking down the executive order that attempted to restrict it. This decision is final, applies nationwide, and covers children of visa-holding families exactly as it covers children of undocumented families. No new paperwork is required. If you are an expecting parent on any visa status or any status at all, your child born on American soil is a United States citizen at birth. No pending litigation threatens that going forward. No future executive order can undo it, and no additional filing is required to secure it. The uncertainty that defined the last 18 months for families like Priya and Arjun is now resolved for good. This video is for educational purposes only and does not constitute legal advice. Immigration law involves details specific to each family's situation. Always verify current guidance through official government sources or consult a licensed immigration attorney before making decisions based on your individual case. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming next.